right, we are back on the record. Then appearances are as they were before. State have their next witness available.
Yes, Your Honor.
All right, let's bring the jury back out.
I don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client. Can that be noted for the record?
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
The appearances are as they were this morning. They are no different. Bring the jury out.
And we have yet to address subject matter jurisdiction, Your Honor. I still haven't been shown any verified proof that
All rise.
this court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later, if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this the
please.
military
All right,
power?
Can you please take the jury out? Thank you.
Why did the judge put up with that? I mean, that's a question that we've been getting for months here at Sight Sounds Flavors on YouTube, sightsoundsflavors.com. It's just one of those things. I mean, you know, so many YouTube channels have talked about it, but yet none have really hit the nail on the head, and that's exactly what we're going to try to do here. But before so, I want to invite you to please subscribe to the channel, ring the bell for notifications so you don't miss a single video. Also, if you haven't done so and you'd like to, smash that like button. It really helps, and leave a comment down below. And the really good comments inspire new videos. So, have a little bit of my big gulp here. Got to stay hydrated when making videos on YouTube after all. But, you know, a lot of people really don't understand. You know, you got the judge, and, you know, she was so, like, frustrated with Darrell that she would even say, Mr. Brooks, please, you know, like thinking that, you know, her desperation would get to him, maybe register with him, maybe he'd understand that, you know, what he was essentially doing was sabotaging the entire court proceedings. And that, you know, look, if you want to, you know, get a little bit of leniency in terms of your witness lists, and maybe in terms of the order of your witnesses, because you know that he had a huge issue with that, maybe you might consider being, I don't know, like decent. Maybe you might consider not stalling the process, not interrupting witnesses, not badgering witnesses, not, you know, staring down the prosecution, not staring down the judge. But you see, Darrell Brooks Jr. not only didn't understand the legal process, didn't understand procedure, didn't want to educate himself. Instead, he was absolutely adamant about being as outrageous and as just indecent and inappropriate as he possibly could be. And this is a prime example, you know, and you can see, because I'm sharing with you a clip that is, you know, a little bit longer than the average clip that I share, still obviously fair use and still within the scope of fair use, but it's a little bit longer because, you know, you see him make, you know, 3 or 4 of the same canned statements, trying to get a rise out of the judge. You know, that's not my name. I want it on the record. It's on the record. I'm not going to address it. You know, I want to keep the record clear. The record is clear. Well, I want to make sure it's extra clear. I'm a third-party intervener. No reaction. Subject matter jurisdiction. No reaction. You know what I mean? You know, can you make sure that you're unbiased to preside over this proceedings? No answer. Is this admiralty court? Is this military? By that point, you know, the judge has just had it, and she's got to, like, instruct the bailiffs to have the jury stay out of the courtroom. And then she just, you know, she's at a point where she's just almost like just so frustrated that she, again, shows some emotion to this psychopath, whether it's saying, this man is scaring me, or it's saying, I'm so helpless that I can't even bring the jury into the room because I can't control this defendant. You know what I mean? I'm not going to send him to the other courtroom. I'm not going to send him to the holding cell. But I can't have him here because he's not, I can't even get the jury in the room. And so it's not a knock on Judge Doro. It's not a knock on the prosecution. It's simply an observation. And it's one of those things where I think that's why so many people continue to look at this trial months and will continue to look at it years after its completion. It's because this is an example of one of the most incorrigible defendants, pro se or otherwise, in a court proceeding. And I think that, I don't know why he was allowed to get away with as much as he was, but he was, and he was able to do it. And a lot of people have said that it was because the judge wanted to make sure that he didn't have grounds for an appeal. But, an appeal doesn't mean that, a defendant can stall the process, badger witnesses, stare down officials, stare down presiding officers. And if he's not allowed to do it, well, then he's going to have an appeal. You can't appeal. Oh, I didn't get a chance to, derail the proceedings enough. Therefore, I deserve a retrial so that I can then do it on this next trial. It doesn't work that way. She could have easily put the tape on him. She could have easily put him in the other courtroom. She could have easily have left him in his cell and had him watch the proceedings on a closed caption TV. The reality of the matter is that when he was in the other courtroom and his objections were limited to holding up the piece of paper, that's when they actually got the most work done. And to me, I don't know about to you, but to me, I think that would have been a perfectly fine way to allow the proceedings to have gone on. Because again, if he had an objection, he would raise a piece of paper. She would hear the objection and rule on whether she was going to sustain it or overrule it. And then it went back to, business as usual in the courtroom. And that maybe should have been the way to go about it. A lot of people, I've got my video, what if it had been Judge Opper, meaning that what if Sue Opper, the prosecutor, would have been the judge. A lot of people jokingly said the trial would have lasted 4 days. Now, obviously, it wouldn't have lasted 4 days. That, in fact, would have been a rush to judgment, but it wouldn't have lasted nearly as long as it did under Judge Doro. And I can guarantee you that Darrell Brooks Jr. would not have been able to get away with what he did. I do believe that, you have to also take into account that some of the poor victims that had somehow been able to at least get themselves out of bed, at least get themselves, out and about. I mean, they're never going to be the people they were before this tragedy, before this, I hate the word tragedy, before this outrageous crime by Darrell Brooks Jr., but at least they were at least taking a step forward. He sent them back to that event. He re-traumatized these people. He badgered them. He ridiculed them. Even when one man was talking about how he had killed his mom and how his mom's body was on his car and just, could you imagine having to recant that on the stand on a televised trial such as this, and then to have Darrell Brooks go like this and like looking up and rolling his eyes? I mean, it's to the point where I'm surprised that not a single defendant tried to bum rush him and beat him up, because you see it in various trials. And I'm sure that the bailiffs are ready for something like that. But you even heard one gentleman in the background yelled at him and insulted him. But the reality of the matter is that, he got away with so much. And a lot of people think that, that was not a good look for the court. A lot of people think that, that was not necessary to prevent him from having a substantive appeal. So I wanted to share this clip because it's one of the clips that, gets cited a lot in the questions that I get. It's one of the clips that a lot of people reference in the comments to the videos that I post. And it's just an example of how Darrell Brooks Jr. was adamant about, stalling the process. And, I think he got away with it. I think that he got a lot more airtime than he would have, especially a lot more airtime than he would have if he would have allowed the public defenders to run the case defending him. But the reality of the matter is that, he had way more leniency than he should have. And I think that while, the judge and the prosecution did a very, very good job, I think that this trial would also serve as a good sort of learning experience for future televised trials of what not to do, and of why it's not a good idea to let a pro se defendant have a 50-minute uninterrupted rant.